Hello everyone. I am back, sort of. I couldn't sleep and, I got court in a few hours. Got that coming up here in a little bit. And of course, that's sort of keeping me up, but I figured, you know what? I might as well do something a little bit on the productive side for my channel, which I haven't really done as of late. And I decided, I should talk about some Springfield stuff that has come about, that I've learned about. Hey, God brother. Yeah, I'm awake again once more, just like at the same time that you are over there in Australia. But yeah, as is, today is the big start of the court stuff on the criminal side of things. We'll have a chance to see what they have to throw at me, obviously. But obviously we won't be able to know fully the full aspects of what's going on until I actually show up. But for those that you might be in the area or see this, it's over at the Springfield Courthouse at 9 o'clock. I think it was courtroom 2 according to paperwork. That might change though. If you want to do something productive, Bunny Boots Inc., bake some cookies on live stream. That's actually something I had in mind. I actually have purchased 4 boxes of Reese's peanut butter chocolate dessert bar mixes. Yes, Sarah T, I have some juicy Springfield stuff for you. Well, it's not directly related with my case. It does show something that we should probably look at. And on top of that, I figure I might also cover some social media stuff. I figure I might read the so it's only, yeah, 1844, not too bad. That's like 6 o'clock, so for those that don't know military, well, don't know the 24-hour standard. Yep, a live stream. It's almost 2 o'clock in the morning for me. My sleep schedule's still stuck on vampirism, which really sucks. But let's go ahead and transition over to our window here of goodiness. And as you can see, once again, the intro song was Technoax's Noob song, Passion in the Notes. I liked it. I wanted to throw it on. I felt it sort of felt this middle of the night kind of vibe that I have going on here. Not to mention, just sort of a chill stream. I'm probably going to go out. Well, most assuredly, I'm going to go out this weekend unless something comes up. Also, the social media thing that I'm going to cover is partially related because I'm talking with V. He's a prominent Romanian over in Europe, and he talked about the Trump lawsuit was being blocked on social media there, and I figured I'd sort of bone up live on air on some of the case law kind of stuff. But I think we're gonna go ahead and get started at the with the Springfield fun thing. Now, a couple months ago, I learned about a whistleblower lawsuit that came out in Springfield. Now, this is from 2013. Springfield police retaliation alleged. A long-term, this is published by opb.org by Jack Morgan. A longtime Springfield police sergeant on Friday formally accused the city police and officials of disregarding the culture of misbehavior that he claims has existed for years among department higher-ups and retaliating against him for challenging the status quo. So we already got an existing issue from 2013 with police not having a certain kind of thing they got going on. They don't want to lose it. The allegations are contained in a tort claim notice filed by an attorney representing Sergeant Umhofer, a 29-year-old veteran of the police department. The document states Umhofer intentions to sue the city and its police department for intentionally inflicting a severe emotional distress and violation of Oregon's whistleblower law, defamation, and constructive discharge. A claim that basically alleges he was wrongfully being forced into early retirement. The accusation arrives 1 month after city manager Gino acknowledged that former police chief Jerry Smith abruptly retired in April rather than face an investigation into a potentially improper relationship with a female police department employee. Ooh, getting spicy here. Smith had been secretly filmed while on a date with a woman earlier this year. The footage was anonymously submitted to Grimaldi. Yeah, that's probably Grimaldi. And several other city officials. Under city police department supervisor, well, under city policy, department supervisor is not allowed to be romantically involved with any employee they oversee. And I can understand why that is. That's actually quite a strong thing. Hey, beware, mouse. Yeah, I'm awake. Also, last month, the city reviewed an anonymous complaint that had accused Smith, City Captain Rich Harrison, and Sergeant David Lewis of improper relationships with women. Police found no evidence to support the allegations involving Lewis, and an outside investigator hired by the city couldn't substantiate a claim that Harrison had sexual relations in the department's weight room with a city employee whom he later married. Investigators didn't look into the allegations regarding Smith because he'd already retired. Now, here's the thing. If you notice, if there's like any hint of like a huge investigation that could be career ruining, quite often police are allowed to retire or step out, which is fairly interesting. Or at least they will get out of Dodge before anything can really come down on them. Sort of saving their record in a way. Umhofer, 51, didn't directly address that probe, but he claimed Friday in an interview that a number of police department supervisors have engaged in behavior similar to what Chief lost his job for. 9:50. Oh, so it's a morning show for you guys over there in Britalia. I also went and got myself a slushie, so I'm enjoying that right now as I read through this. It got out of hand administratively, and we allowed to become systematic, Umhofer said. According to his claim, Umhofer tried without success for past several years to challenge a system that, in quotes, that served to conceal and overlook misconduct of now senior law enforcement personnel and police administrators, unquote, in violation of established ethical standards for law enforcement officers. Yeah, I guess they wanted to have a steamy romance fling with the potential of getting caught. There is couples that enjoy that. Well, there's people in general that enjoy that risque nightly fun. Ah, the United Caliphate. It's starting to look that way. Okay, it's getting pretty bad over there with the violence. Apparently, the roaming gangs that usually go and just steal motorcycles and scooters and stuff like that have been now robbing people while they're still on the bike because the people have been, how should I put it, locking them up so well it's becoming very difficult to get their hands on. But, hello, Ladybird. But yeah, it's getting interesting. Now, my question is what do they do to start doing the retaliation, which will probably be further down in this article. I haven't read this one, but I've read a few others. We need to arrange our sleep. I'm up with my morning show. You're up with your late show. Yeah, well, technically, this is right now my morning show. I slept until about 11 o'clock and, well, 2300 there, and I couldn't fall back asleep. The UK is what happens when you feel guilty about ancestors' color. Oh, I love your comments, God brother. Anyway, continuing on here. According to, let's see, we already read that. After making complaints, Umhofer was subject to extra scrutiny and, in quotations, unnecessary and rigorous interrogation, unquote, while also having his duty schedules, in quotation, conspicuously changed, unquote, and taking orders from people whose behavior had been questioned, the claim states. Umhofer said that he approached Grimaldi for help with the situation shortly after Smith retired. According to the claim, Grimaldi led the sergeant to believe that his complaints would be properly investigated in a discreet and timely manner. Hey, Bunny, where do I stand on filing criminal charges on cops? If they break the law, file the charges. That's what I got to say on that one, Beware Mouse. But it doesn't always work out how you want them. But, what is a caliphate? It is an Islamic state-run theocracy. And, in fact, actually, in a way, ISIS was a caliphate. Iran, pseudo-caliphate, though it's a democracy. Saudi Arabia would probably count as definitely as a caliphate in a way. Let's see here, continuing on. Let's see, approached in a timely manner. But Grimaldi turned over Umhofer's documentation to the same police officials who should have been subject to an investigation, and who have been named as being part of the culture that Umhofer wanted to see changed, according to the claim. See, this is the kind of bullshit why good officers have a hard time bringing about change within the system. This is the kind of bullshit they go through, and why police departments need an external review process that is not done within. I think internal affairs needs to be revamped, where there's at least an outside opinion looking in on some of these issues that are brought up, or if not all of the issues. Beware Mouse, I don't have answers to your questions, to be honest. Those two questions, I unfortunately I don't have an answer for you on that. City spokesman Neil Luddett said Friday that the investigator hired by the city to look into anonymous allegations involving Harrison and Lewis conducted the review of Umhofer's complaint, one of which accused Harrison of being a police vehicle to travel with women, who is now his wife. Grimaldi issued Harrison a verbal reprimand after determining that the captain had improperly used the car for personal business when he apparently took the woman to lunch. Beware Mouse, I got court for the Springfield arrest when I was arrested back in March. That is still ongoing. That case hasn't been dropped. Hey, Leviticus. Yep, it is a paper tiger. Now, this is sort of quite interesting because this reminds me of an incident where the city of Houston in Alaska, or it's more like a town or village with the population size, but incorporated wise it's called a city. The mayor got in huge trouble for driving a police car all the way up to Fairbanks, and I think it was also given, I think it gave some people rides here and there or whatever. At one point they did have a police force, but they trashed it back in like the mid-2000s. It was quite the interesting thing, and they never have hired a police department again, and there was huge corruption issues within the paperwork of that city, or of the township there. Hey, Ozzy. Yeah, I've got to get some more of the intro, or at least I need to get a soundboard set up. Not guilty. That's what I'm pleading on that, Beware Mouse. I'm fighting that case because it's obvious that my rights were trampled on with it. And besides, the objective of any activist should be to come out with no criminal charges sticking at all to them, and not having a conviction. Let's see. Luddett said Umhofer also accused another department supervisor, who has not been named publicly, of having an on-duty romantic affair. Investigators could not determine that had ever taken place, Luddett said. And in those kinds of situations, it can be fairly difficult, especially if it's an affair and they're most likely already trying to hide it. Let's see. Oh, hey again, lady. Oh, hey. Oh, you're referring to Lady Bird there. Let's see. Luddett also said Umhofer's complaints were reviewed by Lane County prosecutors, who found no evidence of any criminal misconduct, and that the documentation provided by the sergeant was returned to the police department and treated identically to any other complaint. Well, maybe it shouldn't be treated like that when it comes to police in, accusing other police of misconduct and other issues. Eventually, when the investigation is complete, the employee who investigated has access to it, and let it said, they have a right to see their personal file. And I do agree with that part right there. But the question is, what about us civilians who, well, us common guys, not civilians, us common guys who are on the street? Do we have a right to see our records? Sometimes, well, or anything that's filed. Some people, well, some police officers don't want us to show how many times we've been pulled up in certain kinds of databases of systems and what information they got. And we've had improved history on that kind of stuff. I think that's probably a system that needs to be extended to even the general regular bloke on the street. If you plead not guilty, then you're a defendant. Well, a defendant. Yeah, I know, I'm a defendant. Yeah, it's a criminal case. I'm a defendant, and it's going to be quite the interesting court battle. I wish it worked like that, Beware Mouse. It doesn't work like that. Let's see, Umhofer, who has been... let's see here. Umhofer alleges in the claim that he faced an increasing level of workplace hostility after going to Grimaldi for help, and is now taking extended medical leave of absence to deal with emotional, mental, and physical harm he has suffered, which is quite interesting. Let's see, Umhofer, who has been off work for 5 weeks, said Friday that it's unlikely he will ever return to duty. Umhofer worked as a patrol officer and detective before most recently serving as the police department's administrative sergeant and public information officer. He said Friday that he is more interested in seeing a fix in the system. See, you got officers that want to see changes, I mean, positive changes and fixes in the system, but when they try to push it, they get chased out. Then in receiving any monetary reward that could come from either settling his claim or prevailing in a potential lawsuit. His claim does not include any mention of damages that he might seek in a lawsuit. Umhofer said it was difficult for him to start legal proceedings against the city, and he believes the majority of the police officers in Springfield are ethical public servants. Well, I sort of might have to disagree with you a little bit on that, Umhofer, with my what's happened with my current ongoing court case and criminal battle that's going on in the city of Springfield. I didn't want to be here, Umhofer said, filing a tort claim notice. I can very much care very much about the Springfield Police Department, and the majority of the cops who work there on the ground level would give their lives for any citizen of Springfield. Yeah. Well, we'll see how that all turns out, especially with the stuff that we'll probably end up digging up on all of that. But there's further news. As of, let's see, this was posted June 4th, 2015. Ex-cop lawsuit settled by the city. That's what happens when you have a political system of repeal is almost impossible. Yeah, that is very... Oh, you're talking to Lady Bird. Anyway, let's see. The city of Springfield will pay $250,000 to settle a federal lawsuit filed by a former Springfield police sergeant who alleged that his efforts to fight corruption in his department were repeatedly stymied by the individual cost him his job. The attorney representing both the city and former police sergeant Don Umhofer filed paperwork Thursday in U.S. District Court announcing Umhofer's whistleblower lawsuit had been settled by the city. Had been dismissed. City officials subsequently released documents outlining a settlement agreement that brought the litigation to a close. Umhofer, 52, had claimed in the suit filed in October that he was targeted for retaliation and ultimately fired from his job 1 year ago because he had made a habit of speaking out against misconduct in the police department over a period of several years. The settlement calls to make $230,000 in cash payments. More than half of that sum, $125,000, would be paid to the lawyer, a Portland law firm that represented Umhofer in the case, to cover the attorney's fees and court costs. The remaining $105,000 will go to Umhofer to cover unspecified compensatory damages, although the settlement agreement states that the city continued to deny the validity of the claims made by the former police official in his lawsuit. So pretty much what happened was a payoff saying, just go away, leave us alone, and maybe they have something in there, they'll do something, but otherwise we're not going to speak publicly about this anymore. The city will pay an additional $200,000 to $20,000 to Umhofer's retirement fund, who remain an active member of the city's city retirement plan through June 2017. City officials also agreed to deliver Umhofer a Springfield Police Department retirement badge on a plaque recognizing nearly 30 years of service to the city. As part of the settlement agreement, the two sides of the legal dispute issued joint statements outlining details of the deal. Both parties are glad to put this matter behind them, which allowed them to move forward without further distraction. The settlement reads, it also says both sides believe that everyone's the best interest for this to be the final statement on the matter. The agreement includes a non-disparagement clause that prohibits either side from making any further public comments regarding the case. The same clause bars Umhofer from making negative public statements about his employer with the city, and forbids the city and police management employees from saying or writing anything negative about Umhofer. So pretty much it came down to, here's the deal, here's some money, and we're going to shut our mouths. That's it. No more talking, no more mudslinging or anything like that. Or when it comes to any public statements about each other, don't talk about it. When it comes to private statements, don't talk about it. So that's what happened there. And I'm wondering if this kind of same culture is going on right now. And I think it might be. And we'll sort of start seeing that with how things continue with the city of Springfield and all that stuff, and how they want to continue pushing this, because it's very clear that they have some sort of corruption issues going on. Nothing much, R. Garcia. I just went over a whistleblower case that happened out of Springfield, Oregon, where a former police sergeant was forced out trying to bring changes to the police department because of improper conduct among the officers. In fact, the police chief was busted for that same thing and retired because of it in order to avoid any further problems. And this specific officer was pretty much forced out of his job into early retirement because of these said issues and trying to change the corruption problems that were going on within the police department. And as you can see here, it was settled for $250,000, half of which goes to the lawyer, the other half goes to Umhofer. I have to say, actually, you know what? Now that I'm thinking about it, I should probably reach out to this legal firm here and have a talk with them. Maybe they might have some information, or they might be able to help with some stuff. Now that I'm thinking about this. The thin blue line does not like competition. Of course it doesn't like competition. It doesn't like also criticism. But, yeah, that's the fun little thing. And so, let's see here. I got to get ready in approximately, 1, 2, 3, 5 hours. Get ready to go to court. Got my alarm set on my phone, so if I do end up taking a nap, I'll be awake and run over and go and do that. BB, lawyers are not to be trusted. Of course lawyers are not to be trusted. That's why you pay them. You tell them, you better do a job for me because I'm paying your butt. Besides, I'm also I'm going to be working on studying to become a lawyer. So I can't be trusted either. Well, well, you already can't trust me in certain aspects because I'm already diving into the legal stuff. So off topic. Sorry, Prunk and Drivet. Have you been watching Kahlua? No, I haven't watched the latest stuff. I know it's been erupting and new lava flows have sort of popped up here and there, or some new fissures. There's like prostitutes. Pay them to do a job to get yourself to where you want to be in life. Life is good. Pretty much. I love that statement there, God brother. Let's see, just seeing a video of a cop watcher that was detained in Colorado and he won $40,000. Oh, that is good news to hear. Oh, wait a minute. Colorado, $40,000. I wonder if I know who you're referring to, R. Garcia. Because that sounds awfully familiar now that my mind just sprung to it. Oh, and you know what? Speaking of lawyers and issues, you know what? There's something else. Let me see if I can pull that up again real fast here. Oh, News Now. Oh, it's News Now Colorado. Oh, that's good to hear. I'm glad that case has been dealt with. It's, well, the $40,000, God brother, what happened over in Colorado, they actually passed a law, a state law, that penalizes the police departments and the police officers for interfering with someone that's filming publicly and not causing a problem. And News Now Colorado got hemmed up by the cops. And that's what it's actually dealing with. Let's see here. Where is that story? Ah, here it is. Copy link address. Let me get back over to this other window here. And I think you guys are going to enjoy this one here. The Guardian. Plainly unconstitutional. New Orleans jail worker records inmates' calls to lawyers. Sounds like a down payment on an F-150. $40,000 would actually get me by for about 3 or 4 years. Because of how cheap I live. Okay, well, okay, let me, you know, I'm gonna go ahead, we'll pull that up real fast, then, Ladybird. And, we'll play that. How about that? Well, put that in here. Oh!
When people take pictures of government buildings, in particular police department, it does cause some concerns, so some folks let us know. I'm making a threat assessment right now, okay?
Just need some pictures of some marked units.
I'm not buying it.
Okay.
Do you have an ID I can see?
I'd rather not give it. But you have to have reasonable suspicion that committed a crime.
Because you're outside a law enforcement facility acting suspicious. That's all I need.
Is that a felony or misdemeanor?
That's a misdemeanor.
Being suspicious?
Yes.
Really?
Yeah. It's called disorderly conduct.
Disorderly conduct. The Supreme Court has ruled that photography on a public sidewalk is...
We'll do it my way. Come with me.
I'm going to put his camera just on the hood. Your first name is I'm going to take your phone, I'm going to put it on the hood of the car for my safety and my cover officer's safety, okay?
For my phone?
Yeah.
How does it make you unsafe that I'm recording this?
Okay, I'm going to explain it to you.
Oh...
Alright, so what's going on, guys? So, just to give you a little timeline on what's going on here. So, November 2nd was the day that I went and filmed the police department. November 4th, I put out the original video. And November 6th is when they issued a bulletin regarding it, which I will go on to explain here in just a minute. So, let's start with this. On November 2nd, 2017, Clayton was filming the secured parking lot of the Colorado Springs Police Department Falcon substation in Colorado Springs, Colorado. City of Colorado Springs police officers contacted Clayton. just to be clear here, this is a settlement agreement. This is not, they were not sued. This is an agreement saying pretty much that I will not sue them because in good faith we reached a settlement agreement. The parties deem it in their best interest to reach a complete resolution of any and all potential claims that Clayton may have against the City of Colorado Springs, occurring up to the date of this agreement. Basically, I'm resolving claims for this, specifically for this incident. This.
All right, so I want to sort of chime in here. Actually, this is like a pre-settlement kind of thing. This was like, hey, here's money. Don't sue us. Sign this that you're not going to sue us. So that's pretty much what's going on here. And due to the fact that the state has actual laws on the book, well, a law on the book dealing with this specific situation, the city is definitely in the wrong. And while $41,000 is a pretty good payout in a way for something minor like this, News Now Colorado there actually was financially harmed by this incident that caused a lot of problems within about a month or two later, that caused problems not just with him being able to maintain work, but also his residency. So he has damage issues that could be easily filed against the city. He covered this in some videos back, it was in November or December, I can't remember, where he talked about the hardships that he went through because of this, combined with a few other things that happened in his recent past. And so I could see, I think this sort of in a way makes up for a lot of the damages that he's suffered through. I don't think he really made a profit or anything like that on this. Literally, this is compensation for civil rights violations and financial damages that he suffered from this. Let's see here. Springfield PD making waves now. BB, come to Texas. I would love to, but I have an ongoing case over here in Oregon, an ongoing criminal case. Once that is resolved, actually, I have an invitation to go and visit another person that deals with First Amendment stuff and help them get started out. Well, help them get really going and all that stuff. But as is, I told them I got an ongoing criminal case. I sort of got stuff going on. I can't really just drop it and hop over there. Once I get this resolved, I'm more than glad to come and visit him and help him out with that. And I would love to pay another visit over there to Texas. Fix Portland first. Well, Mike Bluehair and his team is working on Portland, so I'm not... If I pop up there, it's maybe to do some video footage and record protests. Yep, E30, that is very correct. That cop went from, I'm trying to justify, to F you. And it's very, actually, what's funny is the cop that arrested me did a very similar thing. Where I sat there, I tried to ignore him, just continue walking. And he grabbed me. And then when I sat there and started, how should I put it? Debating the grounds for stopping me and detaining me, he just went straight to arrest at that point. But let's go ahead and continue listening to this.
All of this is pretty much just agreeing that I'm not going to sue them over it. And then we have consideration, which pretty much this is what they are agreeing to do. And I have to say, before we go into this, like, I'm pretty happy with it. I will say that we, as in me and my law firm, we're definitely willing to litigate it in court. But we strongly feel that...
Ooh, I love this. By July 1st, 2018, the following will be added Colorado Springs Department General Order 1551, Section 4. Taking photographs or recording from public places in itself does not constitute suspicious activities. I love it. I love it. Good work, News Now Colorado. You have instituted a policy change, while not big as in law, but dude, I love it. You have instituted some change. Yeah, I'm cranking up the volume on him as much as I can. I'm gonna have to remember to crank this back down when I start playing other stuff here. Okay, so let's go ahead and continue.
This is acceptable, and these are acceptable terms. So, within 30 days of the execution of this agreement, the City of Colorado Springs agrees to pay the total amount of $41,000 in the form of a check made payable to Clayton and the Kilmer Lane and Newman law firm. Now, Kilmer Lane and Newman is very huge civil rights law firm here in Colorado. I'd say pretty much every auditor here utilizes them. I guess I won't say specifically who, but yeah, you can pretty much figure that out. So next we have City of Colorado Springs will ensure payment of all mediation costs. I'm going to be leaving the bottom section of this out because the mediation is confidential, but pretty much part of the agreement was that they're agreeing to pay the costs of the mediation. By July 1st, 2018, the following will be added to Colorado Springs Police Department General Order 1551, Section 4. Taking photographs and recording from a public space in of itself does not constitute suspicious activity. So a couple things to say about that. My law firm specifically was responsible for them having to publish their policy on the internet. They had to publicly publish it. Now, my law firm specifically, in other lawsuits against Colorado Springs, has had, they have had different things added to this policy, but apparently that wasn't enough. So we had this line. It will be added to the policy by July 1st. Now, I must say personally, you know, we proposed probably 15 different policy changes or adding to it at least, and this is the one policy that was agreed upon. I must say I was personally aiming more for something along the lines of, you know, a police officer shall not detain someone for suspicious activity alone, but rather suspicious activity of a crime, or reasonable suspicion of a crime. You know, that's what the law already states in accordance to Colorado Revised Statutes, Title 16, Article 3, Subsection 103. But, you know, I mean, it is what it is. Here's the thing, though, you know, police are more trained to know their policy than they are the law. That's why they have law books. That's why they have to go through and find codes, because they're not trained to know the law as much as they are their policy. So it would have helped for that to be in their policy, but you know, this is definitely a step in the right direction. So next we have, by September 15th, 2018, the City of Colorado Springs will create and publish a roll call video addressing the First Amendment right to record police activity, and will require that its officers view the video by December 31st, 2018. So yeah, that's, you know, that's pretty self-explanatory, and it's pretty awesome. So basically, by the end of the year, every officer of Colorado Springs Police Department will be required to watch a video about our First Amendment right to record the police. Now, since this happened on November 2nd, I've not had one problem with Colorado Springs Police Department as far as filming goes. I have filmed pretty much every government building in this entire city. Filmed the courts, filmed, you know, I filmed the Department of Homeland Security.
Alright, so we got a general idea here. Let me fix my voice meter there. Okay, there we go, so that way. But yeah, that's quite interesting. Good on you, News Now Colorado, creating change. Hopefully that compensates you for all the hassle and trouble you went through with the after effects of that incident. Each officer has to watch that video for training. Yep, that's the good news right there. But I have to say, this is the kind of change that we're hoping to push. Well, a good change. Oh, what do you know? I can see myself live streaming there. And I'm glad that he's able to do. And so it looks like we got a law firm over there in Colorado that deals with civil rights stuff. And so keep that in mind. If you're ever in Colorado and you have something that happens to you that's civil rights related, maybe you should talk to that law firm there. And that's one of the other things we need to start doing with us people that are activists in the First Amendment cop watching community in general, is if we got a good law firm that's willing to help people out and take cases on these areas, and people have winning cases that they can bring them, we should network and try to get these law firms' names out there and sort of promote them for these jurisdictions that they're able to serve cover. Hey, Maximillionaire. But it's good to see that Colorado Springs is getting dealt with. In fact, actually what's interesting is, if I remember correctly, the Ridley Report had issues with Colorado Springs, I think it was year before last, with the police department and library staff, when he was trying to cover some sort of meeting or something like that. Have a good night, everyone. I'm off to bed. Yeah, hopefully I don't end up getting towed away to jail, so. Jail bed. And the beds in jail suck. Literally, it was a pad that was bolted down to a metal thing. Let's see, Miranda v. Arizona, the claim and exercise of constitutional right cannot be converted into a crime. Thank you, Beware Mouse, for the citation. But I figured before I hop off... Oops, why did that not pop up right? Okay, there we go. I figure we do some reading. And specifically, the Hawaii Defense Foundation versus City and County of Honolulu, which is the court order from the famous HPD Facebook lawsuit. And so I figure, let's go ahead and let's take a reading through this from this court order here. Currently, before the court is plaintiff Hawaii Defense Foundation Christopher Baker and Derek Scammons, collectively plaintiffs. May 5th, 2014. Objections to the magistrate judge Richard L. Pogus. April 22nd, findings for recommendation to grant in part and deny in part plaintiff's motion for attorney's fees. The F&R recommendations recommends that plaintiff's request to see attorney's fees of $64,000 be reduced to $22,000 based on the following. The court adopts in part adopts in part and modifies in the part F&R. Let's see here. On August 21st, 2012, plaintiff filed this action against defendants City and County of Honolulu, the city, and Andrew Lum, collectively defendants, alleging violations of First and 14th Amendments when plaintiff posts to Honolulu Police Department's social media page on Facebook.com were removed and the plaintiffs were blocked from making further posts. Document number 1, compel, let's see, that's just referencing the documents, so I'm going to skip reading that part. That same day, plaintiffs also filed a motion for temporary restraining order and a motion for a preliminary injunction which sought to restore plaintiffs' deleted posts, permit plaintiffs to post to the HPD's page, and prohibit the defendants from banning people or removing posts based on political content. This is going to be interesting. I'm wondering how much this is going to play out with the lawsuit for the First Amendment lawsuit against Trump and his Twitter thing. And I got to sit down and read that. But if they're going against Trump in his personal account, I don't think they're going to have much of a leg to stand on. Let's see. The following several status conferences, defendants agreed to develop a policy through negotiations with plaintiff's proxy, the American Civil Liberties Union, governing public posting on HPD's Facebook page. So the ACLU was involved with this case specifically. Accordingly, the court deemed the motions for temporary restraining order and preliminary injunction moot. Thereafter, parties engaged in settlement negotiations, reaching an agreement in principle by January 2013, but failing to resolve the form of dismissal documents and issuing regarding payment of plaintiffs' attorney fees and costs. On October 23, 2013, plaintiffs filed motions for summary judgment And defendants filed a motion for judgment on pleadings as to claim the defendant Andrew Lum on January 16, 2014. The parties reached a settlement on all issues except payment of plaintiffs. Minutes preceding the motions were terminated. On January 21st, 2014, the parties filed a stipulation dismissing all claims but acknowledging plaintiffs' right to file a subsequent motion for attorney's fees. The underlying motion for attorney's fees followed, in which plaintiffs sought an award of $64,000. After the FNR recommended the plaintiffs be awarded attorney's fees. Plaintiffs filed their objection on May 5th, 2014, and on errata of May 6, 2014, defendants filed a response to May 21st, 2014. Pursuant to Local Rule 72D, the court finds this matter substantial for disposition without a hearing. Let's see, I want to argue with that, but I don't think I can. Finally got my mind clear from Trump Twitter, now it's back. I'm sorry, Sarah, but how should I put it? Trump's going to always be, because he's the president, he's always going to have some sort of influence on the discussion. And I'm using this as a jump-in. I'm probably going to cut this out as a little highlight or something like that to further. And as I said earlier, this is actually me studying up for a discussion with V, well, a potential discussion with V about this stuff and the legal issues around when it comes to First Amendment posting, being blocked, and not being able to comment on government officials' Facebook pages or social media pages and stuff like that. So, but continuing back on, when a party objects to a magistrate judge's findings or recommendations, the district court must review de novo those portions to which the objections are made and may accept, reject, or modify in whole or in part the findings or recommendations made by the magistrate judge. I feel like what was it, Leonard French from the copyright attorney there, who just reading that same statement. He reads it quite often in many of the court readings he does. But continuing on, under a de novo standard, this court reviews the matter anew, the same as if it had not been heard before, and if no decision previously had been rendered, the district court need not hold de novo hearing. However, it is the court's obligation to arrive at its own independent conclusion about the portions of the magistrate judge finding or recommendations to which parties object, and recommending that plaintiffs request $64,000 in attorney's fees be reduced to $22,000. The FNR determined, among other things, one, counsel hourly rates were not based on applicable Hawaiian market rates. 2, time spent on certain tasks was excessive. 3, time spent on tasks by multiple attorneys was duplicative. And 4, across-the-board reductions of 25% on the remaining hours was necessary to offset counsel's billing in primarily half-hour increments. Plaintiffs object to these reductions, and the court addressed each objection in turn. Plaintiffs object to FNR determination that counsel requests an hourly rate were well out of line with the prevailing rates in Hawaii and should be reduced from $355 to $185 for Richard Holcomb, $325 an hour to $175 for Mr. Brazier, and $250 to $150 for Mr. Alan Beck. Based on de novo review, the court agrees with the FNR that requested rates do not reflect the prevailing rates in the district. Due process means wishing that restrained party fire. Okay, let's see. Swamp. Don't make myself me time myself out of the chat. Let's see. A reasonable hourly rate should reflect the prevailing market rates to the relevant community. Citing case law, the Ninth Circuit, which generally is the forum in which district court sits. In determining reasonable of an hourly rate, the experience, skill, and reputation of the attorney requesting fees are taken into account. Important. the fee applicant the burden of processing satisfactory evidence that the rates he requests meet the standards. Has the burden of producing satisfactory evidence in addition to the affidavits of its counsel that requests the rates are in line with the prevailing in the community for similar service of lawyers reasonably compared to skill and reputation. And so far what I'm seeing is the reason why this went so high up in the first place was over attorney's fees. So I don't actually think this is a case law specifically for the First Amendment stuff as I'm sitting here reading through this. In somewhat rambling fashion, plaintiffs appear to argue that the court should ignore this well-entrenched standard. In particular, the plaintiffs argue that the court should determine a reasonable hourly rate based on Laffey's matrix, which is a grid of inflation-adjusted hourly rates for lawyers with varying levels of experience in Washington, D.C. area, and which the approved in Laffey v. Northwest Airlines out of the D.C. Circuit. Plaintiffs contend that the court should apply the Laffey matrix as evidence of baseline standard that would reflect the true market value of legal services because the courts in this district notoriously award fees far below any reasonable rate on the mainland or Hawaii. Citing fee, would district argue practices to reject evidence of prevailing rates and instead rely on court-reported unsupported knowledge of prevailing rates. Plaintiffs argued that the practice is particularly troubling in light of Honolulu's high cost of living and salary gap between Hawaii and other locations on the mainland. Citing census data, news article, salary gap compared to certain locations on the mainland. The Laffey matrix and evidence regarding the cost of living in Hawaii does not address the applicable standard for determining a reasonably hourly rate. They are not evidence of prevailing rates in the District of Hawaii. Just because Laffey matrix has been accepted in the District of Columbia does not mean that it has sound basis for determining rates elsewhere, let alone in a legal market 3,000 miles away. Some more stuff about the hourly rates. Rejecting a citation, rejecting the Laffey matrix as evidence of prevailing market rates in Hawaii. Indeed, it is irrelevant that attorneys in other districts may have higher hourly rates, or that Hawaii has a higher cost of living and lower salary wages. Rather than the court must determine a reasonable hourly rate in this market based on the hourly rate, the experience, skill, and reputation of attorneys requesting fees. Setting aside plaintiffs' argument to ignore the applicable standard, as the market rates in this district presents declarations of the plaintiffs' counsel detailing their experience and novelty and undesirability of this case, to a Pacific Business News article indicating that cities recently paid out counsel hourly rates between $295 and $495 for work in connection with Honolulu is $5.2 billion rail transit project. 3 citations to numerous attorneys' fees orders in this district. Although counsel experience justifies a much lower hourly rate than requested based on prevailing rates granted in other district court Hawaii cases, plaintiffs argue they should be awarded their requested rates because Mr. Holcomb, I'm probably screwing that one up, has his own practice and has had a number of significant legal victories and publications. The orders in the district show that courts simply apply the same hourly rates based on unsupported assertions that the court is aware of the prevailing rates. The Pacific, number 3, Pacific Business News article suggests the prevailing hourly rates are higher than the rates awarded in the cases the courts reject the plaintiff's argument. As an initial matter, the court finds the Pacific News article unhelpful in determining the prevailing market rates in Hawaii for similar services. The hourly rates listed in the article are not tied to any particular attorney charging such rates. There is no information indicating the experience, skill, and reputation of counsel, and comparing this relatively First Amendment case to a complex rail transit litigation provides no meaningful guidance to court. Yeah, Felipe Hemming's not a lawyer. He stated that many times. His wife is a lawyer, though. The scope and complexity of the work and rail transit project has faced multiple federal and state legal challenges and has several moving parts. It is not all that comparable to the work required in this single case, which has far less contentious and was largely resolved through negotiated settlement. So it looks like the basic issues of this was settlement, and why it went up to the Supreme Court was basically because of the payout. So I'm pretty sure this does not establish case law for the state on it. It just establishes an issue with the payment. Simply put, such comparison is off the track. Nor do the declarations that the council arguments for a higher rate based on experience support plaintiffs' requests for hourly rates. The declarations of counsel describe only their experience and fail to explain how counsel compares to any reasonable rate in this district. Let's see. Prevailing rates. Further, the mere fact that Mr. Holcomb started his own firm does not suggest the council is entitled to hourly rates awarded to attorneys with many more years of experience, and hourly rates that are determined by experience, skill, reputation, not title. And although plaintiff's counsel has had some success in civil rights litigation, the court is well aware of the experience and skill of counsel and finds an hourly rate commensurate with the years of experience and appropriate. Let's see here. In determining the reasonable hourly rates for attorneys with counsel years experience, the court is left with little evidence from plaintiffs described above, and the Lafferty Matrix and the Pacific Business News articles are unhelpful, and the plaintiffs do not provide declaration from other attorneys or even state that their usual billing rates are for paying clients. That is, counsel failed to present satisfactory evidence to support the rates requested. The court must therefore rely on knowledge of the community's prevailing rates, the hourly rates generally granted by the court's familiarity with the case, and plaintiff's counsel submission detailing their experience. And in making this determination, the court finds helpful, despite plaintiff's argument to the contrary, the numerous cases in district discussing prevailing hourly rates in this district. Although plaintiffs argue the rates in these orders must be below the prevailing market rate, given that they're rarely awarded the hourly rates requested by attorneys. Such fact just as easy suggests that attorneys seek higher rates from the court than they may charge a paying client. Indeed, plaintiffs assert that Mr. Brazier and Holcomb share a case that is billed hourly by paying the client at $250 an hour. Yet they both seek an hourly rate much higher than what a single client pays them. Thus, plaintiffs have failed to convince the court that the hourly rates awarded in the attorney's fees ordered in the district court do not reflect the prevailing rates. Rather, given the court knowledge the case and the counsel's experience, the court finds those rates appropriate in this case. And boy, oh boy, this turned out to be quite the what the hell. I thought we were going to be reading case law about Facebook postings, but it turns out no, this is not specific. This part here, like we read more than half of this, and this is just about legal compensation from the losing side here. Although the rates recommended by F&R are within the range of reasonable rates for counsel experience, the court finds that a small upward adjustment to place counsel at a higher end for reasonable rates is necessary given the nature of this case and ensure representation in civil rights case. The court therefore adopts an hourly rate for Mr. Beck that modifies the hourly rates for Mr. Holcomb, who has practiced for 9 years, Mr. Brazier, who has practiced for 7.5 years, to $200 and $185 respectively. Plaintiffs billing half-hour increments. Let's see if we can skip all this stuff. Let's see, hours billed, specific tasks, duplicative time, fees for objection, summary of fees, conclusion. Okay, so literally this was just about the fees. I don't see... Where the hell did they get this? Excerpt from the court order from the Hawaii Defense Foundation. Okay, this is a statement they gave out. File documents can be viewed here. And let's see if we can find... Oh, that reminds me. This is what I was trying to remember where I needed to put that. Let's see. Civil Rights Declaration of Jury. I think this is what we were looking for. Let's get this to full screen here. This is probably... When was this filed here? Okay, this is the opening filing document. And then... I see you guys are having quite the legal discussion there. Okay, this is now... Okay, there we go. Now, let's see. And this was filed 8/21/12. 8/21/12. August 21st. I don't see a stamp on this one. This is page 2 or something? Let's see. United States District Court, attorneys, plaintiffs. So I'm going to have to do some further research on this a little bit later on. And read through this and see what the hell is going on. Because I think, yeah, what happened was this was all settled in district court. Well, settled through mediation. And I'm sort of a little bit confused now because... here's a background from excerpt from the court order. And the court order seems to be specifically dealing with the attorney's fees. And it doesn't deal with the actual case itself. And is this the same one I'm looking at with the... Yeah, so I'm going to go ahead and play us out there with some music. Because this is definitely not what I was expecting. So we get to learn a little bit more. So I'm going to have to do a lot further digging on this one. And also I plan on doing some digging on the San Diego case too. Though I got to figure out, I'm going to have to figure out what is the case name and all that stuff. And see if I can, how I can dig that one up. But it's quite the interesting discussion you guys got going on there in the chat. With all that stuff going on there. Let's see here. So we'll go ahead. I think we'll go back to some jazz music to play us out because that was actually fairly good. And I hope you guys are going to have a good day. I am going to take a break. Maybe take a shower. Try to take a short nap or something like that. Because I do have court coming up a little bit later. Well, here in a few hours. And I want to at least try to stay mostly awake for that. Yes, it is court day, Sarah. So I will be showing up. Just remember, this is not the actual trial itself. This is going to be preliminary motions. This will be setting further trial dates for doing jury selection and other stuff. So we'll probably be only in there for, I can't see no more than 2 hours, to be honest, before before it's over. And I'll probably do a live stream or something like that after I get out, unless I get pulled aside by the lawyer and we'll have a conversation about what's all going on and all that stuff. So, and also I need to file for some public records too out of there. Yep, this is for Springfield. I was never charged with the federal courthouse kind of thing, and I've still got I'm still working on that one on the side here and there for that issue. But right now, my main focus is dealing with the Springfield case and then also dealing with day-to-day life. But I hope you guys have fun the rest of the day. Look forward to further updates from me a little bit later on today. Let's see. Get Homer on the jury. I would love it if I could get a Homer on the jury. And just seeing those antics play out. What's the status of the Springfield case, Bunny? It's still in process. Well, as I said, later today, the city is still trying to push it. We'll find out what exactly they're going to plan on doing with this case. I don't have any new updates. It's just, as is, we just got to wait until I have a chance to get in front of court and see what the hell's going on. But, yeah. And a poo. Oh, yeah, that would be hilarious. But you guys have a good night. Oh, well, good day. And look forward to an update later on today about what's going on with the Springfield case. And let us enjoy some nice, soft jazz.